Hi, everyone. This is Sam Silverman, Managing Partner of EB-5AN. Thank you for taking time to join us on today's webinar. Today, we're going to be discussing adjustment of status with an EB-5 investment with a concurrent filing, which we'll get into. And we'll also spend a few minutes speaking about recent EB-5 visa demand trends. The USCIS recently released the fiscal year 2024 filing data. And so there's some interesting conclusions that we're going to discuss with some of the demand trends as well. All right, here's a quick overview, getting a little more granular. First, we'll start with a quick overview about EB-5AN. We'll introduce our guest panelist, Ahmed Khan, an experienced EB-5 immigration attorney and now executive with EB-5AN. We'll get into how to adjust status with an EB-5 investment and what exactly does that mean? What are the benefits? How does it work? Then we'll shift to some recent EB-5 visa demand trends and talk about some of the newly released USCIS filing data. And then we'll wrap up with a few minutes on available EB-5AN urban and rural TEA projects available now at the $800,000 investment amount. So first, a little bit about EB-5AN, skip over that. We're a leading EB-5 investment fund manager. We've worked with thousands of investors from around the world, many different countries. We've been in the industry for about 11 years at this point, and we own and operate more than 10 regional centers that cover the entire continental United States. One of the things that makes EB-5AN a bit unique among the other EB-5 regional center operators in the space is we're 100% committed to investment transparency. So we make all of the documents available related to an investment available to potential EB-5 investors, including any of the applicable financial statements as well, which is unprecedented in the industry. We've also published hundreds and hundreds of blog posts on our website about red flags, other transparency topics, information about recent filings, and about best practices and thoughts about hiring EB-5 immigration attorneys, along with over 1,000 YouTube videos as well, including over 20 EB-5 investor testimonials from real life investors who've invested in many of our EB-5 projects over the years. As I mentioned earlier, I'm Sam Silverman, one of the two managing partners of EB-5AN. A little bit more about my background and bio is there on the left-hand side. And unfortunately, Mike isn't going to be able to join today's presentation. As we talked about earlier, we operate a national network of regional centers that covers the entire continental United States, along with Puerto Rico and Washington, D.C. And we've worked with EB-5 investors from more than 70 countries around the world. We've also been fortunate to have our information, strategies, and projects referenced in many of the leading publications, some of which are listed here on this screen. And now it's my pleasure to introduce our guest panelist, Ahmed Khan. Ahmed's an EB-5 industry veteran. He's been in the space for many years and has experience both as a practicing EB-5 immigration attorney who's worked on thousands of applications over the years, as well as an experienced EB-5 regional center executive as well. And so I'll let Ahmed jump in and share a little bit about his background and experience, and then we'll jump into the benefits and process for making an EB-5 investment and getting the benefits of adjusting status.
Yeah, thanks, Sam, for the introduction. And as Sam mentioned, my name is Ahmed. I am currently the vice president here at EB-5AN, and I'm also an industry veteran, both as a regional center executive. I've worked with some of the top regional centers in the country, and I've also been an attorney in a past life, working with investors and regional center operators to both track or file immigration applications along with the source of funds, as well as put together project documentation for regional centers sponsoring projects. So at this point, I've seen pretty much all sides of the ball with EB-5, and I've been doing it for over a decade at this point.
Perfect. Thank you, Ahmed. So let's jump into the first main topic we're going to cover today, adjusting status. And I think at a high level, I think maybe let's start with just what is adjustment of status, who can do it, who can't, and then what are the benefits?
Yeah, absolutely. So let's first start with when you can't adjust status. And that's basically traditionally applicants who are filing from outside the US. Everyone goes through the 526E process. And once that's approved, if you're overseas, what you're going to be doing is what's called consular processing. And this is where your application is basically forwarded to the National Visa Center. You pay a fee bill, and then the National Visa Center send your package to the consulate in whichever home country you're living in, and you go for an interview. The visa officer stamps your passport, and then you land in the United States and obtain your green card. Adjustment of status basically is for those people who are already in the US in a valid status, and it's exactly what it sounds like. You're adjusting your current status in the US to that of a green card. So this can be a really big advantage for people who are already in the US because it bypasses what can be a pretty big headache, especially at the consulate level. Different consulates in different countries, especially ones that experience high volume, such as China and India, often undergo really lengthy delays just to schedule an appointment. So that's probably the primary advantage, is just bypassing some of the headache that comes with consular processing. But as we'll talk about today, there's a lot of immediate benefits that these investors can take advantage of just being in the US, and what the adjustment of status does for them while they're waiting for that green card to arrive. And we can jump right into it. So, and I've kind of already talked about it, who's eligible? Well, if you're in the US and you're in a valid visa status, and it could be any one of the letters, right? You could be B1, you could be here as a visitor, you could be a student, you could be already employed on an H or an L, you could have your own business on an E2. There's a lot of different visa categories that qualify, and you should talk to an immigration attorney to see if the visa status that you're in, including some that aren't even listed here, right? We've got people from Canada on TN, we've got people on diplomatic visas. There's any host of visa numbers and letters and the whole alphabet. If you're in the US and you're in status, you've got an opportunity to file an adjustment of status. And in some cases, even if you've fallen out of status recently, you can still qualify to adjust status under EB-5. That was one of the new protections that came in under the Reform and Integrity Act in 2022. So I think the first step is, are you in the US? Are you in valid visa status? Or have you recently fallen out of status? That's a good time to go to an immigration attorney and say, hey, I'm thinking about filing EB-5. Would I be able to file an adjustment of status? Once you file that adjustment of status, that's when the benefits start kind of coming in. So if we go back a slide, Sam, we can basically think about what are some of the immediate benefits that you get. One is you actually get status right away once USCIS receives and receipts your adjustment of status. So I hear a lot of investors say, oh, I'm going to get an EAD. At that point, I'm safe to stay in the country. It's actually much earlier than that. As soon as you get that receipt notice from the USCIS confirming that your adjustment of status has been received and accepted, you're now in what's called adjustment pending status. And so you're able to remain in the US physically, whatever happens next, right? So we'll take a kind of example here. Let's say you're in an H-1B role, you filed the adjustment of status, and then 1 week after you receive the receipt notice for your adjustment of status, you get laid off, right? And 60 days pass, and you haven't found another job, no other H-1B employer, and you haven't gotten your EAD yet for whatever reason. Could you still stay in the US? And the answer is yes. Even though you can't work at that point, right? You don't have work authorization because the EAD hasn't arrived yet. But just physically remaining in the US, you absolutely can do just from the filing of the adjustment of status. So that's a really big advantage, especially for those who have kids in school, maybe have undergone layoffs with their company, or maybe in between jobs by choice. Maybe they're looking to start a company. Maybe they're looking to, just be an investor. whatever the case may be, it allows them to maintain their status quo until they get their green card. So that's the primary advantage. Point three here then is the one that everyone kind of points to, and it is a huge advantage, right? While you're waiting for this green card, especially if you're in a backlogged country, and we'll talk about that a little bit later, then the EAD really does give you broad work authorization anywhere in the United States, right? So having that EAD is basically giving you the same work benefit that a green card would. A green card allows you to work for anyone, anywhere in the United States, including yourself. And an EAD card under this category, under the C9 category, which is for adjustment of status, EADs, you have broad work authorization, able to live and work anywhere in the US. What also comes with that employment authorization document, often as a combo card, sometimes separate, is called an advanced parole. And this is essentially just advanced permission to leave the US and then return. It's a travel permit. So basically, let's take another example where you're, on H-1B, you decide to file the adjustment of status, but in the meantime, your H-1B visa has now expired. If you're Indian or Chinese, you know how hard it is sometimes to get an appointment overseas to get a new visa stamp done. Well, the advanced parole or the travel permit here will save you from that headache. You can now leave and re-enter the U.S. without having to get re-stamped and worrying about all that. So that's obviously, the two big immediate benefits. The timing for this can vary anywhere from a month after you file the application that you receive these two cards. Sometimes it can be 6 to 8 months. We are all at the mercy of USCIS processing times, but generally it is within a few months of filing that you get this benefit. We'll talk a little bit about what the steps look like once you've got a green card, and obviously the whole purpose of doing an EB-5 is to get the green card, but the adjustment of status really does provide a bridge from the time that you apply to the time that you have a green card in hand. So it's a really, really big advantage that the RIA, by providing concurrent filing, right now you can file at the beginning of this process versus only after your 526E is approved. It provides a really big advantage to investors who previously didn't have it.
And Ahmed, what is the duration, the validity that we're seeing for these EADs and for the advanced parole travel? How long is it typically valid for once you get it initially? And then are all the family members getting it, or is it just the primary applicant?
Yeah, that's a great question, Sam. So the rule was actually updated just last year, and USCIS now issues 5-year EAD, and we've even seen advanced paroles coming in for that 5-year mark. And so the initial approval is for 5 years. For a lot of applicants, particularly those in rural areas, that's going to carry you to the green card issuance. But even let's say you're in a highly backlogged category like high unemployment, which we'll talk about, and you're from a backlogged country, you can actually extend that EAD and advanced parole for as many terms as you need to get the green card itself. So let's just say it gets crazy for some reason and it takes 12 years for you to get your green card under an EB-5 application. You actually could still maintain your EAD and advanced parole all 12 of those years. That would be 2 extensions, 5 years, and then a third 5 years, and then you obviously get the green card in the middle. So it really does, at this point, bridge whatever timeline you have from the day that you apply to the day that your family receives the green card. And it covers the entire family, right? The only limitation here would be if you have young children who are not legally allowed to work in the US because of their age, they wouldn't be receiving EADs. But pretty much the entire family, spouse, children, everyone included in the application, everyone that's part of the immediate family would get an EAD and an advanced parole.
And another question that we commonly receive related to this is, well, what's the difference between getting the green card and having the EAD and advanced parole travel document in terms of my employment options and just flexibility in terms of working and entering and exiting the US? Let's say if I want to travel to Asia to visit family, like what's the difference?
Yeah, and the answer is not much. This really is kind of an amazing benefit to people who have applied for adjustment in categories that allow for it. The reality is that an EAD gives you the same work authorization that you get with a green card. And now that we've got these 5-year EADs, you've got a lot of room to breathe, right? You're not worried about extending or renewing your EAD card every other year. You've got it for 5-year blocks at a time. One of the other protections that under this category is that if you're filing for a renewal of an EAD, just the receipt notice of that will actually extend your EAD for a certain amount of time while you're waiting for the new EAD application to be approved and for that card to be issued. So there's a lot of protections in place, and the US does this on purpose. The government is basically understanding that they are often the bottleneck in the immigration process, and the EAD and advanced parole really is meant for investors to maintain their status quo and basically start their lives in the US because they're filing in a category that more often than not leads to a green card issuance in the near future. So the answer to your question, Sam, is yeah, really not a big difference. You really do enjoy a lot of the same benefits in terms of travel and work authorization that you would with a green card when you have this EAD and advanced parole in your hand.
Perfect. All right, so let's kind of look at the order of operations here for an investor considering doing EB5 and just take a look at where does this adjustment of status step, where does that fit in? And obviously this is an optional filing. And let's talk a little bit about, why would you want to do it? Why would you not want to do it potentially? And, how early can you do it if you're making an EB5 investment?
Yeah, absolutely. So first, let's just break down the simple step, then we'll talk about maybe some interesting situations where you may want to strategize this a little bit differently. When you're making an EB5 investment, obviously, one of the things that the government's looking for when they pick up your 526E is that you've made the investment, right? So the first step really is to work with a regional center partner to sign the subscription booklet that any offering will have, essentially signing up for the project, reserving your spot, and then transferring the investment funds, right? Once those funds hit the project escrow, and that's how 99, if not 100% of projects will set it up, is your funds are moving into an escrow account to be held. That's then the green light for your immigration attorney. And we'll talk about why having a great immigration attorney is really important as well. But your immigration attorney will now have the green light to file 4 different applications. And let's talk about what each of these are. So the EB5 is just basically going with the 526E, right? This is the equivalent of an I-140, which is filed for an EB1, EB2, or EB3 application. The 526E is kind of unique to the EB5 experience, but it's the same equivalent. It's basically petitioning the government to provide approval for a green card to be issued. Now, in conjunction with that, what's called a concurrent filing, the government now allows for the 485 to be filed alongside the 526E. And the 485 is the adjustment of status. This application includes the medical exam that a lot of people will know about at this point because USCIS has now made it a requirement before filing the 485. Previously, it was a little bit optional. It will look at your immigration history. So if you've got 20 years of H-1B experience, you're going to have to show 20 years of approval notices and extensions and things like that. And basically, it will ask you a lot of questions about your admissibility to the U.S. if you've been arrested, if you've got any basically marks on your record that would lead you to be inadmissible. So that's what's being adjudicated in the 485. Now, when you file a 485, there are various different categories that it falls under. But when you're under an employment-based petition, like a 526E or the EB5 category, you get certain benefits. In this case, you're able to file for a 765, which is an employment authorization application, and a 131, which is a travel authorization. So all 3 of those, the 485, the 765, and the 131, all get filed kind of together. The 526E also gets filed at the same time. And think of it as 2 different packets. The 526E will go to the Immigrant Investor Program Office, or the IPO, and the 485 will go to whichever service center, depending on which state you live in, within USCIS. Okay. Now, once it arrives, the first question I always get is like, well, the 485 is probably going to get processed right away, right? Not exactly. What's going on is that the 45 is kind of moot. It's useless until it has an underlying benefit approved. In this case, the 526E. So the 45 is actually going to sit for a little while until the IPO approves the 526E application. Once the 526E is approved, the 45 will get picked up. They'll process all that. They'll look at your immigration history, and then you'll be approved and you'll receive a green card. But even though the 45 is kind of sitting there, USCIS will separate the 131 and the 765 from that package and actually start adjudicating that right away. The basis for you getting an EAD and an advanced parole is simply that you filed a 485 in a category that allows for concurrent filing. It's as simple as that. So the 765, I-131, 45 has been accepted. You're going to get those two cards. I get the question a lot, okay, is it risky? Am I not going to get it? At this stage, there's very little that can be done to lead to a denial. It would have to be something really outside even the bounds of something that I know of, because I've only ever seen it happen like once, and it was a really extreme situation where someone was on a watch list internationally. So if you're not on an international watch list, you're probably okay. And so that's the reason, that the fact that they separate these applications out and actually look at them, and they're only looking at the basis of the 485 being filed, that you can get an EAD and advanced parole, even though the 526E and the 45, as we see in our chart, comes later. Those have not been approved yet or even adjudicated. Okay, so you filed the 526E, you file these three other applications, you get the EAD advanced parole. A few months later, you'll get the 526E approval. This now kickstarts the 485 process. So within USCIS, there's actually a system for this. The officer will be notified, who has your 485, that the underlying benefit has now been approved. They'll approve the 485. You'll receive a green card in the mail. And then about 21 months later, you'll get to the point where you'll file an I-829, which we as a regional center take care of the majority of that work of proving that you've created the jobs. And in some of our projects, you already know that those jobs are created even before you file the application, and you get your permanent green card. So it's a little bit, there's a lot of steps here. I think the thing to really pay attention to for our purposes today is you get that concurrent filing of all those applications at once, and you get that very early benefit of getting a 765 approval and a 131 approval, and all the other stuff will happen down the road. There's a lot of different factors, project type, country of birth, that will determine the timelines for those later factors. But that first half, the top half of this chart, should be the same for pretty much anybody filing while their visa number is still current. You're still going to get a EAD card. You're still going to get your advanced parole, even if you backlog at a later date.
Ahmed, great, thank you. Let's since you have a lot of experience working with investors as an immigration attorney, let's spend a few minutes and talk about what does that filing process look like. If you were acting as an immigration attorney today, what does your process look like in terms of collecting the information to fill these forms? Who's filing it? Are there filing fees? Like, how does the client kind of interact with their immigration attorney once they've picked a project to make sure that all these separate forms get filled correctly and get submitted, on time, that there aren't any mistakes?
Yeah, absolutely. And I think the first step really is just choosing an attorney that is going to be responsive. This process requires a lot of back and forth. There's just no such thing as a perfect process. And I hear it a lot. I'm sure, Sam, you do too, where an investor's like, oh, my source of funds is going to be super easy. I've got it all in just, savings. It'll be a piece of cake. And then the attorney starts digging in, and we're, 2 months later, we're still not done. And the reason for that is USCIS does have a pretty high standard for what they're looking for when it comes to source of funds. So working with a responsive attorney from the get-go is a really good way to make sure that everything is done in a timely manner. If they're not responding to you quickly, you're not having the conversation that you need to have to sift through the documents and move on to the next set of documents that you need to provide. the way that I always did it, and I think that a lot of attorneys still do, is they understand that the bottleneck here is a source of funds process. And so you'll get the forms and everything done through immigration software. They'll send a client the questionnaire that they need to fill out that will help them basically fill out the forms. And then they'll send the forms to the client to review. And this should be a pretty early step, right? Regardless of which project you're choosing, regardless of you know how your investment is going to move through this the source of funds process and the path of funds process, a lot of the information on these forms is going to be just your biographical information, especially on the adjustment of status. So getting those to you quickly, and then yeah, you might have to add in the project information when you finally made that selection. That can come at a later date, but at least having the bulk of it completed and ready to go is a big part of it. Working with an attorney that understands that you're likely going to culminate, within a 1 to 2 week period where everything should kind of line up, right? You should be making the project decision around the same time that your source of funds is basically ready to go and all the documentation has been collected, and you're going to be making the investment kind of as the very last step before you file the application. If you do it right, if you transfer your funds on a Monday, by that Wednesday, you should be ready to file the application. I think we still see a lot of attorneys that, maybe even tell investors to go ahead and wire their funds early, and then we'll work on the source of funds. Well, that can lead to a lot of problems, right? What if the source of funds isn't clean where they transferred from? So it really, it can't be overstated just how important it is to work with an attorney who has a process in place. Every attorney is a little bit different in how they do it, but making sure that they're aware of the timeline that you're trying to meet, right? Let's say you've got a particular need to file by late February, you communicating that to the attorney, and they're giving you set timelines for when certain steps should be completed so that you can get that filing out the door and make sure that you meet whatever deadline it is that you've imposed for yourself.
Got it. All right. That is really, really helpful. All right. So I don't think we need to spend much time on this, but maybe Ahmed, just 1 minute kind of summarizing how these different steps kind of overlap and the order.
Yeah, exactly. And so this is just illustrative of what I already talked about, right? Your 5260 and 45 go in, and together they do take a little bit longer to be completed, but the initial kind of benefit is going to be that 765 and 131 being approved and giving you that EAD and advanced parole. The 829, it does come at a much later date. That's probably a good topic for another day where we talk about, how you can safeguard yourself for a future application like the 829. But for today, I think the big focus really is just understanding that the green card, especially with backlog kind of impending, and we'll talk about that today, that might take some time. It could take, a year and a half, all the way up to 3, 4, sometimes even longer, 6 to 8 years. But if your immediate kind of goal is to secure your future in the US, get some flexibility in terms of work authorization and not be, subject to your employer's will, then just filing a concurrent filing and getting that EAD and advanced parole is usually a big step in achieving that.
Got it. All right. All right. We already, maybe Ahmed, just spend 2 minutes just summarizing each of these as well.
Yeah, absolutely. So, we talked about some of the advantages of an EAD and advanced parole versus a green card, and you'll see here that it really is very similar in terms of the benefits that you're getting, right? The peace of mind of a green card is its own, but other than that, the authorization that you're receiving is very, very similar. I think the main key for an EAD is that you do have the ability to work anywhere in the US, and it's broad work authorization. What do I mean by that? It means you can have 2 jobs, you can have 3 jobs, you can have no job, you can work for yourself, you can start your own business while working for somebody else. There's any number of kind of combinations that people can get into that are actually going to be 100% okay with an EAD in hand. It gives you broad work authorization with almost no restrictions in terms of what you can do. And so, yeah, if you wanted to work, a day job and drive an Uber at night, you're free to do so. If you wanted to work on your startup while also working at a big tech company, you are free to do so. A lot of these restrictions are in place with H1s, with L1s, with E2s, with E1s, with TNs. with F1 OPT, you can't do a lot on those visa statuses outside of just the main job that you're being hired for because you're completely dependent on your employer. And EAD gets rid of all those restrictions and gives you the freedom to work as you please and where you please. It also gives you the ability to get a social security number. A lot of folks who have been in the US for several months probably already have this, especially if they're in a working visa status, such as a TN, E2, H1B, L1, or F1 OPT. But if you don't, this will give you a pathway to get the SSN, the social security number, which makes life a lot easier in the US. It allows you to open bank accounts. It allows you to go and get credit opportunities like bank loans for a house that you're trying to buy. Just life gets a lot easier once you're a taxpayer in the United States. Um, and very similar to the advanced parole, a question I get a lot is, oh, well, is it just the same as a visa? It really is. It's an advanced permission to leave and re-enter the US. Now, CBP has been known to give people traveling on an advanced parole a slightly more difficult time than if you just have like a green card, for example. You may have secondary processing, but there's no legal reason to turn you away at the border. And I've never heard of anyone being turned away just because they are traveling on an advanced parole. So it really does give you the freedom to travel anywhere in the world, right, that you have a visa for or travel authorization for, and ultimately return to the US without having to worry about getting a visa stamp for whatever other category that you're currently in the US for.
Perfect. All right, let's talk a little bit about some considerations to reduce immigration risk and how the EAD kind of fits in with some of these, and not just fits in, but kind of compare and contrast across some of these other temporary work and student visas, and why the EAD is so much more flexible and beneficial.
Yeah, so before we do that, let's talk about the top feature on all of these, which is the intent to immigrate. And you see that the H1B and the L1 are anomalies here because they have what's called dual intent. And just a basic immigration lesson, what's happening here is when you're coming to the US on a non-immigrant visa, this would be a B1, B2, an F1, a TN, an E2, any number of categories, basically besides H1 and L1, you're essentially promising the government that you're going to leave in a short period of time, usually within 6 months or whatever the defined period is of your education or whatever the case may be. The adjustment of status obviously is kind of on the other side of this, right? You're not, at that point, you're now planning on staying in the US permanently. And so what this does is it creates a little bit of a paradox between the intent that you had when you entered and the intent that you now currently have of adjusting your status. My best advice is, if you're in one of these non-immigrant categories, like the E2, F1, D1, speak to an immigration attorney. In a lot of cases, especially if you've been here for some time and you found out about the EB-5 and you're now looking to file one while you're here in the US, that's perfectly acceptable, right? A change in circumstances, if there's a reasonable person standard that's applied to this, it's okay, right? So it doesn't mean that you're doing something wrong, but there's certainly different ramifications that come with that, and you should speak to an immigration attorney to understand what the timelines are. You can't file too quickly after re-entering the U.S. You certainly can't, make kind of certain actions too early, and so it's important to speak with an attorney and strategize correctly so that you're not raising questions about your intent in the U.S. Each category is a little bit unique, but I think what's kind of true about all of them is that they all come with restrictions. Okay, a B1, B2 is probably the most restrictive. You're not allowed to work at all in the United States. You can really only do certain business things. So, incidental work while you're in the US for a foreign company is allowed, right? So maybe you're checking an email here and there, but substantively working on US soil while traveling on vacation, for example, is actually not allowed. And so B1, B2, extremely restrictive. Getting an EAD immediately solves that problem, right? You're going from basically no work authorization to all the work authorization you could want. The F1 and the E2, both I'm going to talk about just briefly. The F1 comes with certain restrictions depending on what part of the F1 process you're in. If you're in CPT or OPT, you're restricted to just that one employer, and you're restricted by time, right? You only have a certain amount of time 3 years if you're STEM, but only a year if you're a non-STEM major to work in OPT, and less than a year if you're in CPT. EAD solves that problem. You're now able to work anywhere, right? It doesn't have to be with a specific employer that's very similar to the degree that you're in. And it doesn't have to be for a specific period of time. Same with the E2. The E2, either you're an essential employee at a business that is owned by someone who's a national in the same country you are, or it's your own business that you invested into, and you can only work for that business. So restrictive EAD lifts those restrictions, allows you to work anywhere, own multiple businesses, work for a different employer if you're an essential employee currently, basically do whatever you want. And then H1 and L1, again, although they are probably the most flexible of these categories, they're still very restricted. In H1, you can only work for approved employment from an H1 employer. And I think the bigger thing is you're tied to prevailing wages. You might have been working in the US for 10 years and you haven't seen your salary go up, year after year after a certain point because you're tied to prevailing wages within that industry and in your field. So the EAD really does just remove all of this and reduces your immigration risk of committing some kind of work without authorization or working without authorization or basically falling out of status because you didn't get into the H-1B lottery or something like that. The big thing I think about adjustment of status is, like I said, it saves you from having to leave the country, right? In all of these categories, there are limits, right? H-1B, 6-year limit, L1A is 7, L1B is 5, E2 is 2 years at a time, even if your visa is longer. F1 OPT only gets 3 years. And so the adjustment of status is giving you the safety net, basically, of something going wrong. You can always fall back on that. If you're happy at your job or your current situation, I think a lot of attorneys will tell you to maintain your current status. And that this would be, you can see it on all 4, 2 through 5 here, F1, H1B, L1, and E2, to maintain your current status until your 526 is approved. This is really just to be conservative and give yourself multiple options in the event that something goes wrong. If your 526E is denied for source of funds reasons, it's rare, but it does happen, then you don't have to worry about kind of refiling a new H or refiling a new L. You're just maintaining that status, and you don't change your status quo.
Got it. All right. Now, let's say even if you hire the best immigration attorney and you file everything correctly, there's still a chance that there could be an issue because unfortunately USCIS just does make mistakes, right? This is a government organization run by humans and mistakes do happen. Let's talk a little bit about kind of one of these mistakes that we've seen a few times recently and why it's so critical to work with an experienced immigration attorney who's filed hundreds and hundreds of applications and has likely seen this type of mistake happen and knows how to quickly address it.
Yeah, absolutely. And I think we're looking at two of the most common mistakes here, which is things getting lost or things just not being received correctly, or USCIS's internal issue or our internal system just not working, having some kind of issue. It's really important to have an attorney that's diligent about this, right? They're checking your status at least on a weekly basis, if not daily, to see if there's any progress in your application or if there's something that's missing. And really just, you work with an inexperienced attorney, they're probably going to see this and freak out. They're going to be like, oh my gosh, something is wrong. Something's happening. They may not know that this is actually pretty common that with USCIS. And it's not a reason to worry, but there are certain avenues and steps that you should be taking proactively to force USCIS to provide the information that is missing. And we see that here on the right-hand side where an attorney reached out, clearly a experienced attorney reached out, mentioned that the 485 was actually filed, even though USCIS was saying that it wasn't, and it was rejected basically in error. And if you have a zealous attorney that's advocating on your behalf, that knows the game and knows USCIS makes mistakes and has all those records and everything in place ready to fight back and basically say like, nope, it wasn't us that messed up, it was you, USCIS. They'll often, USCIS will understand and give you the benefit, like we see here on the right-hand side. So yeah, as Sam has mentioned, it's super important to work with an experienced attorney who's dealt with these situations before and so therefore knows how to handle each situation, who to contact, which department to push, what emails to send. We used to work with investors all the time who they entered through CBP, and they just entered willy-nilly, didn't really care about anything, but their I-94 was actually updated incorrectly in the system. They'd entered maybe as an H-1B investor, or sorry, H-1B visa holder, but the officer put them in as an F1. And that would technically mean that you're working without authorization because your I-94 is incorrect. Well, someone who's not experienced with this might freak out and not know what to do. But we worked at Fragment at the time. I was working at Fragment at the time, and that's a really big shop with a high volume of cases. So you see a lot of situations like that. We knew exactly who to contact at CBP to get that updated and get that fixed, so that the foreign national didn't accrue any basically work without authorization or anything like that. So yeah, it's super important to work with an experienced immigration attorney. USCIS, like any government organization, is not perfect. They're going to make mistakes. Mistakes are okay, right? It's if your attorney's on your side and zealously advocating on your behalf and making sure that those mistakes are fixed. A mistake that goes unchecked is what really becomes a problem down the road.
Yep, exactly. You just don't want to be working with an attorney that's just going to mail your application in, and then you're not going to hear any follow-up and no updates. That's where you could potentially have an issue.
Yep, exactly. And I think that, to your point, we see a lot of people who, and it makes sense, right? We understand that EB-5 is very expensive and people want to save money wherever they can. The immigration attorney is probably not where you want to skimp on a couple of grand, because trust me, that's probably the most important partner you have besides the regional center operator in the project, to really safeguard every aspect of this process to make sure that everything goes smoothly. And things will inevitably go wrong, but they're the ones who are going to make sure that they fix whatever it is that's having problems.
And Ahmed, maybe before we dive into some of the recent EB-5 visa demand trends, maybe just high level, and now, since you've been on both sides, what are kind of the roles and responsibilities with respect to the regional center and the project? And then, on the immigration attorney side, pretty much everything related to EAD, AP, 526 approval, all the immigration stuff is all really on the immigration attorney, right? So kind
Correct.
of, how are those two roles, separate, and why is it so critical to have the right advocate on the immigration side?
Yeah, absolutely. I mean, as regional centers, our job really is all on the project side. We provide a lot of these resources. We've been in this industry for a long time, and we want investors to be educated about their options before making a decision. But at the end of the day, we are really only responsible as a regional center for the project side of the equation. We're the ones who are basically making sure that the development and the developer are doing everything to meet the immigration standards that are set forth by USCIS for any project that you're investing into. And that is job creation, that is expenditure of capital in accordance with the business plan, that is making sure that we're tracking everything so that when it comes to 829 filing time, everything's ready. We've got that initial kind of job of getting the 956F filed and approved by USCIS, and I know at EB-5AN we've been incredibly good about that and getting those approvals very quickly. But then also there's the second step, which is the 829, and I think this is where a large regional center operator that's been doing this for a long time really separates themselves from a small operator who's starting off on their first, second, third project. A regional center that's been around is going to know the amount of work that it takes over the course of 4, 5, 6, 7, sometimes even longer years to get the 829 done correctly for investors, right? Backlogs can really extend the timeline that regional centers are under the gun, so to speak, with an 829. Newer operators, often they're more business minded. They're getting into the EB-5 space for business purposes, less so immigration purposes. And they're not going to focus as much on how much depth you have to go into on the tracking and everything else that goes into the 829. I mean, we're literally seeing how every dollar is spent, that is spent in accordance with the business plan on EB-5 eligible costs, and therefore creating jobs required for EB-5 purposes. And that's not an easy task, especially when you're not focused on it as your primary kind of goal. So, or your primary job. So regional centers, big experienced regional centers that have done this for many years, that's super important. And then similarly, on the immigration side, the person who's responsible for filing your application and ultimately getting you a green card in your hand is the immigration attorney, right? They're working to file your case within a regional center, the investment that you've made, but they're advising you on the source of funds, which is really the main obstacle to getting the 526E approval. They're advising you on all of the different things that you need to do for the adjustment of status. And I'll give a really good example. You know, if you're not an experienced attorney, you may not keep up with current trends. You may have missed a bulletin by USCIS, and USCIS can change things on the fly within just one day of notice. And they did that recently. Previously, you could file a 45 with no medical exam and just wait for an RFE. And you know, people did that very often because a medical exam can take a few weeks to obtain. Well, USCIS kind of had enough of that and said, we're going to require you to file with a medical exam at the time of filing, or you will just be rejected from the get-go. And an attorney who didn't know that might have filed the application with no medical exam, gotten rejected, you know, a few times, and that could be a major issue if you've got like a kid who's aging out and you needed to file, you know, within a certain timeline. So super important to work with an experienced attorney who knows what they're doing, not only on the EB-5 side, but just all the immigration ramifications that come with these various different applications, not just so they get everything right, but that's so they can properly advise you, right? If you went to an immigration attorney and you said, hey, I need to file by January 31st, and the immigration attorney told you everything but that you have to get a medical exam, and January 31st comes around and everything is ready, guess what? You might still be 4 weeks away from getting that medical exam and filing your application. So experience matters. Paying that extra little bit of money can make all the difference between not only getting an approval, but just having a great stress-free, worry-free process.
Perfect. Thank you, Ahmed. All right, so let's shift gears now and speak about some of the recent EB-5 visa demand trends. So we'll look at some data, and just big picture, EB-5 demand is up significantly. When we look at filings from 2023 compared to 2024 in that far right-hand column, you can see there's almost a 90% increase year over year from 2023 to 2024. And so, Ahmed, yep. what are some of the main reasons, the main drivers that you're seeing, you know, over the last 24 months? Why in the last 12 months? What's driven demand up, you know, and caused it to nearly double?
Yeah, I think, you know, going back to the old tagline that a lot of regional centers used to use back in like 2016, 2017 is EB-5 works, right? And I think that's kind of the thing that people are starting to see and start to have a little bit more belief in. You know, the program lost a little bit of its credibility in the COVID and post-COVID era because, well, the program was very volatile. We didn't know what the amount was. Any given month, the rules could change. We didn't have any stability, and we weren't seeing a lot of approvals. I think you can see the approved rate is really, you know, drastically improved, and that's the other number that I think has caused for a lot of people to have confidence in EB-5 again. So seeing those people file in early 2023, receive their approvals, I know that we're, you know, I think we're over 200 approvals at this point from since the RIA, the Reform and Integrity Act, really provided a clear pathway to filing an EB-5 application and getting that green card. And then the early kind of adopters of that and filers within the program now receiving their green cards and sometimes as early 2024 and sharing their stories. We've got a bunch of testimonials on our website of people getting their approvals in a timely manner. That's what led people to say, hey, this is something that I can really get behind and go forward. And that drove a lot of demand. We also saw a big spike in 2024 of approvals. And I think, you know, this is not just approvals of people filing post-RIA, but even people who filed pre-RIA. This was USCIS's first year in a long time where they've really put an emphasis on getting people approved and issuing those visas abroad. And that's really encouraging for new investors. Not only does this mean that in the short term, We're starting to see people actually move through this program and obtain their green cards very quickly. But it means that we're starting to clear out some of those backlogs that have been really plaguing this program for a long time, particularly for Chinese nationals. And the quicker that USCIS processes these applications, the less visa waste there is that carries over to other categories. And the more we see people as success stories. And success stories, I think, are really what always drive any program, especially with investment, right? When this much money is involved. And you can see here that when we look at kind of the trend, everything is trending upwards in the right direction for EB5. Sure, we're seeing a lot of applications and receipts being filed, but we're also seeing a lot of processing. And significantly in 2024, we saw a lot more petitions processed than were filed, which is great. Seeing processing outpacing demand is what we want to see with any government program.
Perfect. And I think this slide may be a little bit out of date at this point, but this really kind of quantifies what the trend has looked like in terms of rural TEA I-5 to 60 applications. And you can see here over time, the processing of these applications has just gotten a lot more predictable. You see a lot more of the points of data there, in the second half of 2023 to present, just really closely clustered around that trend line. And also, almost all of them, kind of post July 2023, are being processed and approved within 10 months, which is really exceptional compared with some of the prior year processing, which was taking several years. Maybe Ahmed, spend a little bit, tell us kind of what the difference is between the rural versus urban, and why we're seeing this significant improvement in processing times.
Yeah, I think there's two key things to take away from this chart, and to your point, we're seeing that downward trend of processing time, and I think the first reason obviously is with rural projects you get priority processing, and there was a lot of talk early on like, oh, we don't know what priority processing is, unless it's defined, we don't know if USCIS is actually going to do it. Well, I think we're past that point. USCIS is clearly prioritizing rural applications. We're seeing a huge amount of volume of approvals relative to high unemployment, and we're seeing that time get lower and lower for approvals within specific projects as well. And I think that brings us to the second point, which is the 956F kind of process has really worked. Whereas previously, it's not a novel idea. The 924 exemplar is kind of the legacy form that USCIS used to use for exactly the same purpose. You would file with your green card application, and you would, with your project information, and USCIS would conceivably approve it, and then all the investors in that exemplar or in that project that's received exemplar approval would now just be looking at the source and path of funds. In practice, that didn't really work in the past. The exemplars could take 2-3 years, to the point where people just started waiting for the 526 to be approved, and that was their exemplar of sorts, the first 526 in the project. Well, now USCIS has really cut down on the time for 956F approvals. I know we've gotten some approvals in as little as 2 months. And so I think this chart really signifies the importance of going into projects that have 956F approval. You go into those projects, and USCIS is now no longer kind of tasked with looking at the project and waiting on that project to be approved before looking at your source and path of funds. They can just go dig straight into your source and path of funds. And Sam, I know we've both seen clusters of approvals within projects that have that 956F approval. So the likelihood of you gaining that approval and getting your green card much faster definitely increases, and the timeline for that decreases if you're going into projects with 956F already approved.
Yep, exactly. And these are very good statistics to ask for when evaluating any potential project. So one of the things that we're really focused on at EB-5AN is providing all the available data, including this data, which is really proprietary to us and in terms of investors in our projects. But it is data that you want to ask for if you're considering an investment in any other EB5 regional center project, just so you can see, okay, how have your projects fared, right? How long is it taking investors to get their approvals in some of your prior projects, right? That's a really important piece of data that you want to understand and should be able to be provided, when you're considering making, this type of large investment.
Correct.
All right, Ahmed, do you want to kind of summarize some of these receipt statistics that we've broken down here by country, and kind of talk about, what these trends really mean for new investors who are considering filing in 2025?
Yeah, so what we've done here is basically extrapolate a couple of different data sets. One, basically just being the amount of filings that we've seen, and this is really the only statistic that we get readily from the government, and it's usually a quarter late. So we're always looking backwards and kind of seeing what we can extrapolate from that. And we've also taken into account the breakdown between how many people are filing from within each country. And really, the two big players are always going to be China and India, and then the rest of the world falls into the rest of world category. So, what this really shows us, I think, at a macro level, is that urban demand and supply has essentially outpaced rural to date. We have seen over the last few months that rural is starting to catch up as urban becomes more and more retrogressed, clearly. But to date, we're still looking at a pretty clear indicator that urban has outpaced rural. And that's been true even on the per country breakdown. So rest of the world, it absolutely makes sense. They're not historically backlogged. They're going to choose sometimes projects in more urban areas. A lot of these countries like Taiwan and Korea, those investors gravitate towards urban area projects because a lot of where they live is urbanized, and so they're more familiar and it's just a much different cultural dynamic. For Chinese and Indian investors, the calculus is a little bit different, right? They're balancing at the end of the day the timing for the immigration along with whatever project that they're choosing and terms and the investment term and all those other different things. It's getting to the point now where we can very clearly see that there's a long backlog developing for urban investors. The key issue here is that we're seeing how many visas are required in total. And I think what people don't understand is, yes, there are country protections. It's only 7% per country. So, for example, the urban high unemployment, technically you're only going to get 70 visas for both India and China, 70 each. And then the rest of the world gets all of theirs, right? And then you kind of are at the, okay, first come, first served basis. And so because the rest of the world has really taken up a large portion of these filings, it's not a non-zero number, especially in the high unemployment area. Well, they're gonna take up a lot of those visas, and there's not gonna be a lot of visas left over for Chinese and Indian applicants, and that's why we're kind of just looking at the total number of visas required and how much are available in a given year. With carryover in 2025, we're just over double for both rural and urban. And even, with these kind of pretty conservative numbers, we've only used 2 applicants per application, or 2 family members per application. In reality, that number is probably somewhere closer to 2.5 or 2.6. You're still looking at a shortage for visas in both categories. And the Department of State has already warned us about this. They're seeing exactly what we're seeing, and they've listed that on the visa bulletin and the January bulletin, just noting, hey, look, we don't know how bad it's going to be just yet. We don't know which countries are going to be backlogged just yet, although we know it's likely going to be India and China, but it's coming, right? And so I think the question really now for investors is, when is it going to happen? How bad is it going to be? And my answer to those investors is, it doesn't matter, right? The long term here is not changing one bit. You were already backlogged when you woke up this morning. You're going to be backlogged at the time of filing 2 or 3 weeks from now. What really you need to ask yourself is, do I want to file an adjustment of status? And if you want to file that adjustment of status, you have to do it before the bulletin backlogs. And we know it's coming. It might be coming for both categories. It's very clearly coming for high unemployment. For rural, it might only be a few months, or it may not happen at all. Just kind of depends on how the Department of State sees those numbers playing out. But if that category changes from C on the visa bulletin, which stands for current, to a date, if you're filing after that date, you're not going to be able to file an adjustment of status. So that's really the big worry for a lot of investors is, Am I going to get those immediate benefits? Am I going to be able to file my adjustment of status? And you probably only have a few months to do that if you're in that boat. Historically, we've gotten that warning, and within about 3 months, we've seen the backlog actually hit the calendar, or say hit the bulletin. In India's case, in 2019, it actually hit even sooner, just 1 month later. I don't think it's going to be next month. We would have gotten a little bit more specific warning, but I think 3 months is a pretty good estimate to expect a backlog to either hit or be very close to hitting. And remember, when that is the case, a lot of people are filing their case. A lot of people are going to be filing their application and getting in. And if you're an investor who's thinking about EB5, there's no time like the present, right? You don't want to end up in that last little bubble of bunch of filings. We saw that in November 2019, before the program lapsed. Everyone kind of knew the program was going to sunset. They weren't sure how it was going to come back, or if the amount was going to be higher, or what was going to happen. And we saw an incredibly high amount of filings in November 2019, and it took USCIS up until now, basically, to adjudicate all those. So you really want to beat that rush if you can. If you're watching this webinar, chances are you're considering EB5, you should probably go ahead and talk about it with your family and pull the trigger sooner rather than later. When is going to be your deadline to really get in and make sure you can still adjust status? It could very well be as early as March. We're maybe just a few months away from that being the case. When will you know when you have to file by? You're only going to get about 20 to 25 days of notice. The visa bulletin for the following month is published in the current month. So right now, if it's January, let's say 10th, you will just find out what the February bulletin looks like. Until January 31st, you are now able to file your application as is. The status quo is maintained until February starts, and then February's visa bulletin will dictate. So once a cutoff appears on the visa bulletin for the next month, you have until the end of the immediate month to get your application in. If, for example, let's say in February we find out that March is backlogged, the March bulletin is no longer current, you'll have until the end of February, which is already a short month, to get your application in and file concurrently to get that adjustment of status.
And so, Ahmed, let's say that was the situation that you were in. Like, what do you have to do within that 3 to 4 week period to get your application in? Like, what has to happen, and what does the submission look like, and the paper filing, shipment, like what actually has to happen? If you haven't done anything, like, what are the 10 steps that you have to go through within that 3 to 4 week period to meet the deadline and still be able to get the adjustment of status benefit?
Yeah, it's a tall order. If you've not even hired an attorney at that point, you're probably going to be scrambling just to find an attorney who's willing to take on your case. I'll be honest, when there's this much volume, there's probably 100 EB5 attorneys in the whole country. I'm not sure how many of them are considered to be, A plus or A minus or whatever the case may be. And so there is a very limited amount of practitioners out there for a large amount of people who are filing their applications. And so, if you haven't hired an attorney, you're going to be floundering just to find one who will file your case in the timeline that you need. You have to get all of your source of funds paperwork done before then, at least to the point where the attorney feels comfortable filing your case. And they may very well, be only, let's say you have to go and get bank documents and you're only able to get them after 1 week. Well, that week may go by and the attorney may not even have time to review and say that everything looks good enough to file, and you might be dead in the water. You have to get the project selected. You have to go through all your due diligence, right? You shouldn't be rushing with $800,000 just because there's a deadline coming up for adjustment of status. You want to be sure that your money is safe. You don't want to cut corners. You don't want to get talked into something just because someone's pressuring you from a time constraint. And so what I'm really trying to get at is you got to start now, right? You got to start as soon as possible, because the last thing you want to do is get stuck with maximum 3 weeks remaining and have to go through a subscription process, an investment process, moving your funds, collecting your funds, sourcing your funds, getting everything ready, understanding all the tax liabilities of moving money from overseas or into this investment, understanding all the immigration ramifications, the restrictions on travel, the restrictions on work, all the different strategies that you have to kind of undergo when you're doing an adjustment of status, all of that has to be done in 3 weeks. So it's, I would venture to say that if you've not got an immigration attorney hired already, looking at your documents by the time a visa bulletin drops with an impending deadline, there's a really good chance that either a mistake is going to be made because you're rushing through, or an attorney may not even be able to file your case because you just haven't started early enough.
Got it. All right. Thank you, Ahmed. All right. Let's shift and chat a little bit about 4 different EB-5 projects that we have currently open and available, and provide some kind of contrast, and maybe also, Ahmed, share a couple real life examples of why a certain profile of investor may prefer one type of project over another. And maybe let's start with the rural projects.
Yeah, so rural projects are going to be, anyone who's from overseas, anyone who's from a backlog country like India or China, anyone who's prioritizing obtaining the green card in their hand, all of these folks are probably going to have a rural project at the front of their mind. And the reason for that is they provide an incredible immigration benefit of priority processing, of a much lesser backlog. We kind of looked at that slide and we saw the numbers. If you're Indian or Chinese, you're looking at maybe a 1 year backlog at worst. It might even be zero backlog. So if you're from a traditionally backlog country, or you're coming from overseas and getting that approval quickly so you can make your move to the US is important to you, then a rural TEA project is definitely the project for you. We've got 2 great options currently. Rocky River it's following on the heels of our Twin Lakes project that was hugely successful. Hundreds of investors that trusted us with their money in that project, and it basically mirrors that project in just a new location. It's part of the Crestwind brand under the Culture Group. Culture is A+ developer that's been operating and working with us in the EB5 space for over 10 years. We've got numerous successful projects with them over the years. And this community is now the 15th that they're building in the last 15 years for active adults in the southeastern United States. So yeah, it's a really incredible opportunity. It comes with a USCIS approved repayment guarantee format that makes it incredibly safe for investors who are looking to invest, and it provides that benefit of priority processing. Similarly, Tamarack Resort is a project that we're working on in Tamarack, Idaho. This is a resort that's midway through its development timeline. A lot of the amenities in that resort are already built, already operating and generating cash flow, and they're now using that to expand the residential portion and some of the facilities in the resort itself. So the big benefit for EB5 investors here is they're coming into a project midway. It's already generating cash flow. They're not worried about future values, future construction progress. They're getting job creation from the past construction. They're taking advantage of that. And because there's already so much value in here, our collateral and having a 100% security equity pledge and senior mortgages on most of the property, that really puts EB5 investors in a great place from a safety perspective on the financial side. And we already talked about the immigration side as well, having the 956F approval and all jobs already created. Now let's switch to maybe an investor who's in the US, who wants to file an adjustment of status, get those immediate benefits of an EAD or advanced parole, but they're okay with a slightly longer immigration timeline, right? This is going to be for investors coming from maybe Latin American countries, Canada, Europe, Korea, Taiwan, really any country that you were born in that is not traditionally backlogged. You might consider an urban TEA project. The really big selling point for these is you still get the same very, very conservative underwriting that we do in our rural deals, right? We're looking for safe projects for our investors. But because we have a lot more options to choose from, we're able to put together a better deal for investors, right? In the sense that you can often get your money back a couple of years earlier because we're going into projects that are already under construction. They're already fully permitted, fully entitled. Construction is actively underway, and you're able to take advantage of that and kind of come in and get your money back much sooner. For some of our projects, like the equity option here in Boynton Beach, this is again with the same developer in Coulter. This is actually in their backyard. They've got a long history of about 30 years. Never failed to complete a project, never failed to repay a loan. This is, as asset classes go, multifamily tends to be a little bit safer, especially on the rental side. And Coulter is basically providing us with an equity opportunity here for investors where they can earn a slightly higher return than you typically see in EB5. For us in this project, it would be a 5% targeted annual preferred return. On the other side, we've got One Tampa. This is more of the debt style project where you are secured with a repayment guarantee from the Coulter parent company. Another project that already has active construction going on today. You can actually go into the site and see active construction progress being made. And they've already sold over 100 units within this building before a single brick has gone in to building this building. They're going vertical next month. And before they've even gone fully vertical, they've sold over 100 units in the building. So both these projects on the urban TEA side are 956F approved. All four of these projects offer something different in terms of investor priority, but they all kind of follow the same guidelines of being safe investments that are going to meet all of the immigration requirements for an EB5 investor. So depending on what you're prioritizing, whether it be maybe a slight return, maybe it's a shorter investment period, maybe it's shorter wait period for the green card, maybe it's a lock-in, your child's age, all of these things, you kind of have to look at from a holistic perspective and then determine which project is right for you. And at EB5AN, we definitely have a portfolio to choose from that will work within the kind of goals that you've set for yourself and your family through the EB5 visa program.
Perfect. Thank you, Ahmed. I think two main points just to kind of summarize here are, for those investors who are more concerned or more focused on getting their capital back faster, the urban projects are going to be the way to go. If you're more focused on getting the green card, for whatever that underlying reason may be, getting the green card faster, rural is going to be the way to go, right? And kind of the reverse will be true, right? If you're in an urban project, you're going to be getting your money back faster, most likely, but you're going to be waiting longer for the green card because it's not priority processing like rural, and vice versa. Rural green cards coming faster, but the investment period is going to be a little bit longer, right? So you just kind of decide, given your investment situation, your financial picture, family members, immigration goals, benefit of the green card versus the work and travel permit, what is more important to you, getting the green card faster or getting the money back, with a targeted investment return faster, and then kind of apply that framework and then select, the most compelling urban or rural project that makes sense given your unique situation. The second thing I want to mention is that regardless of what project you end up selecting, before you can even really focus on project selection, you've really got to hire the immigration attorney, go through that source of funds process. That can take, as quick as 2 weeks, but it can often take, 6, 7, 8 weeks, depending on how many documents are going to be needed, are translations going to be required, how easy is it going to be to track down, that birth certificate from a foreign country. If money is coming as gifts from friends or relatives, you're going to have to work with those family members or friends to provide all the documents, bank statements, tax returns, showing how they accumulated the funds legally before they've gifted them to you. So there can be a lot of documents needed, and you can't really finalize your project selection and invest money until that first step is completely done. Right? So once you decide you want to do EB5, first step, interview a few immigration attorneys. Ahmed and I have worked with many attorneys over the years, and all attorneys are not equal. Some are better than others. And And also some are going to be better than others given your unique situation, right? If we have a client
Right.
from Canada versus a client from Spain or from China, the best attorney for the investor from China is not going to be the attorney that's going to be best suited for the Canadian investor, right? So you want to make sure that you're speaking with a few attorneys that have experience working on similar source of funds packages, to what yours is going to look like, and we can help kind of get you in touch with a few different options that you can select. And we're completely independent from any of these immigration attorneys. You can hire any of the ones we recommend, or go to Google, type in EB-5 attorney, hire whoever you like, no restrictions whatsoever. You just want to make sure that you're hiring an attorney who's experienced, responsive, has integrity, and is independent from the regional center that you're considering the project with, and also is going to be able to get your application done within a reasonable amount of time, and ideally before any visa retrogression hits, visa backlog issue. That way, you'll absolutely be able to adjust status and not have any issues. Ahmed, any final thoughts you want to emphasize there?
Yeah, I think you kind of hit the nails on the head in terms of making sure that making sure that you're hiring or working with an immigration attorney is step number one, right? Whether you decide to work with EB-5AN or any other regional center, just getting your foot through the door of this process and getting underway is the first decision that you have to take. And the first step really should be hiring an immigration attorney. And to Sam's point, we're completely impartial in that process. We're happy to introduce you to 4 or 5 or even 10 different immigration attorneys that we know will do a good job with your case and have a past record of success. And you're more than welcome to find one on your own as well. But just getting through that step and having the attorney on your side is, if you don't have that, then you're not any closer to getting your application filed. So we can't stress how important it is to get that step underway, to have your process underway, and to understand all the different requirements that are going to be that you're going to have to go through in terms of documentation, signatures, etc., to be able to file your application in a timely manner. And yeah, the window is closing for adjustment of status. We've known it was coming for a long time. Since the RIA, we just didn't know when it would come. And yeah, now we're almost 3 years into the RIA and it's finally here. It really is go time, I think, so to speak. So now is a great time, if you're on the fence, to go ahead and make that decision. Speak with a trusted representative, like an immigration attorney who's done this hundreds of times, and ultimately speak to your family and make the decision to move forward.
Perfect. Thank you very much, Ahmed. And for anyone watching who's interested in arranging a time to speak with me or Ahmed and get more details about the process, introductions to potential attorneys that can help with your application, or to get more details about any of the projects we discuss or others that become available later, please go to our website or use this QR code, and we'll be happy to arrange a time to chat with you and get you any of the information that you'll need to make a fully informed decision. So thank you again for the time, and yeah, we look forward to hearing from you.